So the plea agreement has, and there's no sentencing killabrew on this. Is that correct?
No.
This is the plea to the count one, the misdemeanor count.
Yes, Your Honor. Okay. That's correct, Your Honor.
All right. All right. And Mr. Silverthorne, is that your understanding of the plea agreement? It's going to be an amended count one of use, which is punishable by 1 year and or what's the use?
$1,000.
$2,000. With that amended count one of plea, it'll be 1 year and $2,000. That's your understanding, Mr. Silverthorne?
Yes, Your Honor.
All right. All right. May I inquire of Mr. Vasquez of his misdemeanor advice of rights?
Please, Your Honor.
All right, Mr. Vasquez, you understand you have a right to a jury trial today. A jury trial, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question witnesses that are brought against you. You are represented today by Attorney Dwayne Silverthorne. He would be present to cross-examine any witnesses and contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you please accept, you'll give the claim the plea was results of any promises or threats that it was not your choice to plead guilty, so only what we put on the record. You'd also giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the amended count one of use of cocaine. Is it your wish today to plead guilty to waive your jury trial rights and plead guilty to the misdemeanor instead?
Yes, but I do have a question about.
I think I know what he's going to
Yeah,
ask. It's possession of cocaine, heroin, or other narcotic. It would be another narcotic.
Okay, another
Specifically
narcotic.
Oxycodone.
Okay, perfect. All right. All right, with that understanding, it is your wish today to plead guilty to the use of Oxycontin.
Yes.
All right. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
I'm going to bring your attention back to August 12th, 2025 at Martin Luther King and Jolly in the city of Lansing. Were you present on August 12th, 2025 at Martin Luther King in the city of Lansing?
Yes, sir.
And at that time, did you use the controlled substance of Oxycontin?
Yes, sir.
And you knew it was Oxycontin?
I'm sure Oxycontin and
Oh.
oxycodone have some relationship, but for the record, we should probably specify it was oxycodone.
Codone.
Yes. I'm sorry for interrupting.
No, none. No problem there. Oxycodone. So you did use oxycodone at the time?
Yes.
And you did not have a prescription for oxycodone? All right. And you knew it was oxycodone when you were using oxycodone?
Yes, sir.
Anything towards the factual basis, this all occurred on August 12th, 2025 on Martin Luther King.
Yes.
Anything towards the factual basis, Mr. Smith?
People are satisfied.
Mr. Silverthorne?
Defense is satisfied. Thank you.
All right. The factual basis of the plea has been knowing, voluntarily, and accurately made, and will refer to probation. So probation is one floor down, and what they're going to do is going to prepare a report for me, and then we'll see what options we have available to us at sentencing. Okay. All right. The sentencing date of. Yeah, it'd be 1:30. July 23rd at 1:30. All right, so we'll set the sentencing date is set for July 23rd at 1:30. And if you go down and see probation, I don't know if they'll see you today or if they'll make an appointment, but they'll prepare a report for me.
Okay.
Anything else for the record in 26-00902, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Silverthorne.
Nothing from the defendant. Thank you, Your Honor.
All right. All right, Mr. Vasquez, we'll see you on July 23rd at 1:30. You should get a notice from my court officer.
Okay. Thank
Right.
you.
Thank
Thank you.
Would it matter if I did? We're gonna run the exam.
Okay, so which one do we think we're running?
We talked about this earlier.
That's Tavon. All right, let's see what we can move before. All right. All right, so Mr. Silverthorne, is this Miss Culberson?
Yes,
Okay. Did you need a minute to speak with her?
I spoke with her yesterday
All right.
at the gym.
And then Mr. Lee, you have Mr. Stanford.
I do, Your Honor. I'm going to check in with the prosecutor right now and I'll be.
All right. All right. I just want to see, it looks like we're going on McLeod, and so I want to see if we can move anything out of the way before, but I think Mr. Stanford is in custody.
That is correct,
Okay.
as is Mr. Lee.
Okay.
Yeah, I'll have some answers for both of them in just a moment.
All right. And then Mr. Feigelson was here. He's going to be a plea, I think. And then we'll call Ms. Culberson when Mr. Smith gets here.
It's fine, Your Honor.
Good morning. All right, Mr. Smith, let's call Miss Culberson. And then right now we're going on Miss McLeod, is that correct?
Yes, we are running.
All right. All right. All right, so we're on the record. I didn't even add. Okay. We're on the record in 26-01319. That is people of the state of Michigan versus Takesha Culberson. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Takesha Elaine Culberson, who is standing to my right at council table.
And ma'am, you are Takesha Culberson, is that correct?
Yes, I am.
All right, thank you. This is the time set for a preliminary examination today. Mr. Smith, how are we proceeding?
Your Honor, at this time, I believe the defendant has agreed to waive the preliminary exam, except that there is probable cause for binding this matter over to the circuit court. So at this time, the people will unconditionally waive the right to a preliminary exam.
All right, and Mr. Silverthorne, is that a fair statement?
Yes, it's not part of a plea bargain, but it was an understanding that was placed on the record is that this case is going to go to circuit court along with the case that in 26-436 that was before Judge Babcock last Friday, I believe. And it's going to be an attempt at a global resolution. Both those cases.
All right. All right. Thank you. May I inquire of Ms. Culberson of her waiver of the preliminary examination?
Please, Your Honor, do.
All right, Ms. Culberson, you understand you have a right to preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dwayne Silverthorne. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it would be your wish today to waive your right to preliminary examination, have this case continue to circuit court where there's another file where another file is going to meet in circuit court and negotiations are going to continue and it's anticipated there'd be some type of global resolution. Is it your wish today to waive your right to a preliminary examination today?
Yes.
Mr. Smith, do the people also waive their right to preliminary
Yes, we
examination?
do, Your Honor.
I'll say I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes. Mr. Smith, I might draft you to.
Yes.
Thank you. Thank you, Mr. Metz. All right, so I'm in possession of the bind over documentation on 26-01319. It's been signed by all the parties. I'll indicate that the examination was waived on today's date. That's June 11th, 2026. Is there anything to come to the court's attention before I sign the bind over documentation? Mr. Smith,
Nothing for the TV.
Mr. Silverthorne.
Not at this time.
All right. Ms. Culberson, your time in district court is done. You're off to circuit court, but you'll get your next date of appearance from your attorney, Mr. Silverthorne. All right, ma'am? I'm going to sign the bind over documentation, Mr. Silverthorne.
Yes, before you sign the bind over document, it occurred to me that if you sign that, then I can't renew a motion on bond.
You can feel free to renew the motion on bond.
Okay, we were here a week ago, and the court left the bond as it was on two cases. On 26-1319, I think it was this case, I think it's a 200 cash surety, and then on 25-3647, which is pending sentencing before your honor on the 6th, it's 100. Since then, Judge Babcock, in the other case that I referred to, which is 26-436 FY, granted her a 5,000 PR bond with a tether. So if she gets out, if the court were to re-entertain a motion for a PR bond on the two cases before it today, she would have that tether, and she's also got an additional 26 days in jail. Otherwise, she can't make either, although I would agree they are modest bonds, and she'd have to wait till sentencing on July 6th.
Yeah, my problem with, I don't have the sentencing file, so I don't know the nature of the sentencing file on that. I do have this file that's set at 100 cash surety, which is a pretty minimum lower bond, and she's got at least 3 priors. So let me see if I have let me grab the sentencing file and take a look at it.
Sure, Your Honor.
Thank you, Marcy. So on the sentencing file, the recommendation is jail on the sentencing file. And you're in, and so the credit at time on the sentencing file on February 4th, 2026, when the pre-sentence was done, was a credit for 15 days. She's accrued sometime since then. Is that correct?
Another 26 days.
All right. All right, on the sentencing file, do you have any, I don't know the, I just know it's set for sentencing on July 6th, you said, July 6th?
On that file, well,
Yep.
of course,
Oh, well,
she did appear that day. She just,
that's a different.
I think had not been adequately prepared that jail would be a possibility. And she panicked and ran, and for that, of course, she's now done an additional 26 days. I've since explained to her that what's recommended is not what's required that a judge do.
Right, it's just a
But
recommendation.
she just panicked and fled.
All right, I'm not going to change the bond on the sentencing file. My sentence is 25-03647. There's another file out there.
One for today's different number.
Yeah, That
These is
this
26.
So I won't change on the bond on that. There is there's a 100 cash surety bond set on this case. Mr. Smith, any questions concerning or any response from the city on the 2601-319 set at $100 cash surety?
Your Honor, I would defer to the court. I just, the alleged theft in this case occurred at 314 South Pennsylvania Avenue. And the complaining witness is Tyler Thune. She is present in court today. If the bond is amended, I'd ask that the defendant be placed on a GPS tether with an agreement to not contact or come within 2,000 feet of that residence for Ms. Tyler Thune.
All right. Mr. Silverthorne, any further argument?
No, I don't have a problem with that. As I said, if your court were to grant the PR bond in this case, and she could post the bond in the sentencing, in the case for which she's going to be sentenced here in July, Judge Babcock has already indicated that there should be a tether. And I'm sure that the victims in this particular case could be added to that tether.
I'm not going to change bond. I'm going to deny bond, the request for bond at this time. That the $100 cash surety is
I don't have an income, sir. I can't.
correct, but you have 3 priors, ma'am, and so
Can you turn this to 10%, please?
it's $100 cash surety. All right, and then the sentence is going to stay the same because we can't get you here for sentencing. Okay, that has become problematic. So I'm denying bond on this
Someone
for
tell me.
2601-319 and on the sentencing file. Anything else for the record in 2601-319?
Oh, I do have another case. in
Ms.
there.
Smith, Mr. Smith.
Another room of people, Your Honor.
All right. All right. I'm going to sign the bind over documentation. Your time in district court is done. You're off to circuit court. Will you get your next appearance date from your attorney, Mr. Silverthorne? All right, ma'am.
I have a question, because I don't want to waive it if I can't get out of jail. How is it possible I'm gonna get out? If you don't have a bond. set?
It's been waived. So I don't know what
So
to
I
tell
have
you.
to stay in jail until I get sentenced?
Yes, at least on the sentencing file, because I can't get you here on the sentencing file.
So what about the other one?
I'll explain to
All right.
the way it works.
All right.
Although you're standing in this courtroom and you're receiving explanation, the case is now bound over to the circuit court. You'll get the same judge that was assigned to the East Lansing case. And that judge will now have the authority to amend bond. And I can make the arguments before that judge.
This can be revisited in front of that judge, then that circuit court judge.
So I gotta stay there for that one too?
You're right now, I'm sentencing you, and that's why you're staying in. Because you didn't appear at your sentencing.
So I'm sentenced to what?
I don't know. We're gonna find out in the beginning of July. All right, so that's all for the record on both of those files. Thank you for your appearance.
Thank you.
Thank you, Judge.
Thank you, Mr. Silverthorne. All right, I'm gonna take a recess, and you can talk to someone and then organize. Miss McLeod, Tavion McLeod, my understanding is gonna be a prelim. I don't know, but and then Mr. Lee, just if we need Alva Stanford, let my court officer know. Okay, we'll bring up whoever we need. All right, so I'll give you 10 minutes to talk.
Okay, thank you, Your
They're
Honor.
bringing them up, Judge. They
Yes.
are bringing Alba up, and we also have Marshall and Woody.
Okay. All right, perfect.
I'll stand, I'll rise.
Yes.
You may be seated.
Shemaya? Shemaya? You want to get on you, Shemaya? So I don't know yet.
See that one goes up. Yeah, now I know what you're talking about.
Yes.
Kelly told me that he never says no. I
I look him in the eye and I remember myself.
I gotta
Was
go ask
that?
him.
You want me to let you know when we bring Stanford up?
Yeah, I'll be in and out, but yeah.
Okay.
Take it to the treasurer. She will go into reimburse. Yep. What case are you guys here on? What's the defendant's name? Givens?
Yeah, that's not on our docket today.
He was in Miss or Judge Simmons, but I guess she's not here, so. they-
She's here today.
I saw.
Are you here for a case?
Yeah, my boyfriend,
Who's he?
yeah, there with the attorney,
Oh, he's
Mark Hill.
Okay. Let's see.
What you doing with that one?
Hingham County Council.
Probably waiving as well. Um,
Yeah, we're not bringing him up. Stanford's the one we're bringing up here,
Okay,
because we're gonna be running one, so we want to get everybody.
right.
And if we end up running two, three, yeah. Happy Thursday.
Yeah.
I have Mr. P as well. Okay. What are we doing with that one, Dana?
Supervising Mr. Lee.
Okay.
So I anticipate that we probably will at some point, but
When
looks
was
like
your
meetings
last
is gonna
ask for a return witness report?
MIDC,
Have an
no.
opportunity to interview them. It's really great.
you know,
So, but I'm ready to run it. I don't know about the prosecutor. He won't tell me if any witnesses are here or not. He said it doesn't matter. On my case, so. There's some evidence saying.
You out of here?
Yep.
All right.
So I'm in the line, so like. So I don't know.
I got a lot of stuff.
I don't know what we're
Good to see
doing
you.
with either
I'm
one,
doing coverage day.
which is so odd. Usually prosecutors know. They have their ducks in a row. Maybe this is first time with this. So I don't know, but with Mr. P, I was gonna leave it up to the judge to see if I did the witnesses are here for that case. So I guess we'll all find
Can't
out.
run anything about witnesses, right? At least that's what I understand. I mean,
That's my understanding too. I know. And the puppy who's not potty trained, but you saw the picture, right? Isn't he cute? Oh my gosh.
what kind of puppy?
It's an Airedale Terrier.
Aww,
So
so cute.
we lost ours in October. And he had pancreatic cancer.
I hate that because I had a golden doodle that I lost a year ago this past May,
Mhm.
who had cancer. They gave her a couple of months. She made it 6 or 7 months. But it's just,
It's the worst.
it is.
It's the absolute worst. It's absolute, but, and I still get upset when I think about it. But now we're getting a puppy, and I haven't had a puppy in a long time, so it's gonna be interesting
And fun.
and fun. It'll be fun.
Girl or boy?
A boy,
What's gonna be his name?
Truman,
Oh,
because
okay.
our last one was named Franklin Delano Rothstein. And Truman was the president after FDR, and this will be the dog after.
That is cool.
So
Mr. Smith, did you want these files called together or separately?
Yes, Your Honor. Together.
Together? Okay. All right, so we're on the record in docket 2601-303 and 2601-416. That is People of the State of Michigan versus Alva Joe Stanford. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Alva Stanford.
And sir, you are Alva Stanford, is that correct?
Yes, sir.
All right, thank you.
And my apologies. Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender here also on behalf of Mr. Stanford for MIDC supervising purposes.
Okay.
Thank you.
Perfect. All right, thank you. Mr. Smith, how are we proceeding on these files?
Your Honor, at this time, the people request this matter be adjourned. I've had an opportunity to speak in length with the complaining witness. In this case, I spoke with her over the weekend. We spoke about the facts and the details of the case. It was her intent to be here. She just called me this morning and explained that she had both car troubles and troubles with finding a sitter for her kids. So at this time, we're asking that the court find good cause to adjourn this matter and we work to get the complaining witness here at the next schedule.
All right, and it's the same complaining victim, is that correct?
Yes, on both matters.
All right, Mr. Lee.
Thank you, Your Honor. We would ask the court to consider that the witness was subpoenaed and whatever arrangements that needed to be made for her to be here should have been made. Calling on the morning of the hearing and saying, I can't find a babysitter is unacceptable. We would ask the court to dismiss these charges and allow the prosecutor and the complaining witness to work together to reissue if that's truly their intention.
All right. Thank you. I will allow one good cause adjournment. The witness has had contact with the prosecutor's office in this case. But I will place a note on here that the complaining victim has failed to appear, and so if you can't get her here next time, we got a problem.
Yes,
okay?
Your Honor. I understand.
So, but she did come in contact and make contact with the prosecutor's office. So we'll do one good cause adjournment. Mr. Stadford, you're not waiving any rights today. We're doing a good cause adjournment. And we will reset, and it's got to be post 2 weeks because we need subpoenas to go out. Probably tonight, yeah, probably July 9th. Is that, let's see. That's the following Thursday? Okay. So we'll reset for July 9th at 9 o'clock. On file 2601-303 and July 9th at 9 o'clock on 2601-416. If the people are unable to proceed on the matter on July 9th, we'll revisit the issue. Okay, sir? All right. Anything else for the record in 2601-303 or 2601-416? This is a good cause adjournment to July 9th at 9 o'clock. Mr. Smith.
Nothing from the people, Your Honor.
Mr. Lee.
Nothing for the defense. Thank you.
All right, Mr. Stanford, we'll see you on July 9th at 9 o'clock. Thank you for your appearance today.
Yes, sir. You have a good day.
I have to wait for a sheet still.
Mr. Smith, do you want anybody else brought up?
Yeah, Kimball, Layton.
Yeah, I have Kimball, Layton, and P.
Oh, hang on.
Kimball's entering a plea.
Edwards is not in custody, I don't think.
Come down. We'll bring them down.
All right. All right, Mr. Feigelson, we can bring up Kimball.
Yes, correct.
All right. And then it's Ms. Rothstein, are we going on McLeod?
Yes, we're going on.
All right. How many Mr. Smith, how many witnesses do you intend?
Three.
Three. Let's go ahead and start that, and then we need to take a break. We can get Mr. Feigelson's plea, because they've got to bring his up. Okay. All right.
Watch the exam.
At least a part of it.
Yes. How you doing, Judge?
Pretty good, pretty good. I think we'll be able to get one witness, and in the break, we'll get your guy up.
Kimball. Thanks. Sir.
All right. That's Mr. Lee.
What's that?
The other day, I was talking to somebody about.
Mr. Lee did? All right.
And they're in the 70s. And you're talking about the 75 house.
All right, so we're on the record in docket 26013009. That is people of the state of Michigan versus Tavion McLeod. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. This is the prosecutor, Attorney Dan Smith, appearing on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. McLeod, who's present in the courtroom and seated to my right.
And sir, you are Tavion McLeod, is that correct?
Yes, sir.
All right, thank you. This time set for a preliminary examination today. It's my understanding we're going to go to a preliminary examination hearing. The plan is after we get one witness, because there's more than one witness, we may take a break and have Mr. Feigelson or have some move those cases once they bring up. So that's Mr. Kimball for Mr. Feigelson. And then there was a Mr. Edwards here. And if Mr. Lee wants to go on that, we can go on that. If that's other than a hearing. So that might be after one witness, we might adjourn for a few minutes to move some other things and then call the second and third witness. It is my understanding that we're going to preliminary examination. The parties know the case better than I do, so I'll allow the parties to let me know if anybody should not be in the courtroom to watch another witness testify. There's nobody in the courtroom right now, but I'll be happy to invoke the sequestration order or enforce the sequestration order if somebody comes in who shouldn't be watching another witness testify. Mr. Smith, is there anything else to come to the court's attention before we get started today?
Nothing from the people.
All right. Ms. Rothstein, anything to come to the court's attention on this matter?
No, Your Honor, just would ask that any witnesses be sequestered.
Okay. So all witnesses are sequestered, but I'll allow because people will be in and out of the courtroom, I'll allow the attorneys to indicate if I see anybody in the courtroom, I may identify them just so you know who they are, because they may be a witness in circuit court. With that understanding, Mr. Smith, you may call your first witness.
The people call Officer Noel Milwaukee. there. The judge will swear you in.
All right, ma'am, you can come up here. You're Officer Wanchi?
Yes, sir.
All right. So please state your name and spell your first name and last name for the record.
Noel Mwangi, Noellemwangi.
Please raise your right hand, ma'am. Do you solemnly swear from tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Have a seat. As you know, the microphone does not amplify your voice. It goes right to the court recorder's ears. So please project as best you can. And Mr. Smith, when you're ready.
Thank you, Your Honor. Thanks for being here today, Officer Milwaukee. I'm going to ask you a couple questions about this matter relating to May 13th of 2026, right? Are you currently employed?
Yes,
And where are you currently employed?
Lansing Police Department,
And how long have you been employed with the Lansing Police Department?
4.5 years.
And what is your current role or duty as a Lansing police officer?
I'm a patrol officer.
All right. And have you been in that capacity the entire 4 years?
Yes,
And were you acting in that capacity on May 13th of 2026?
yes,
And were you on duty on that day?
yes,
Did your tour of duty take you to 4201 Chicory Lane, Lansing?
yes,
And is that in obviously the city of Lansing,
yes.
Ingham County, state of Michigan?
Yep.
Okay. And can you describe to the court what originally brought you to that location on May 13th?
Yep, I was dispatched there referencing a domestic assault that had occurred.
Okay. And when you arrived, did you happen to encounter anyone when you arrived?
Yes,
Do you know the name of that individual?
we had Miss Lopez.
And do you know approximately how long after the call went out that you actually made contact with Ms. Lopez?
I do not.
Okay, and when you got there, what was her demeanor?
She was visibly upset.
Okay, and did you investigate the domestic violence call?
Yes,
And did you speak to Ms. Lopez?
yes.
How long did you speak to her?
I'm not sure, maybe 20 minutes or so.
And did she describe the nature of the domestic violence?
Yes,
Did she indicate to you who the individual was who committed this domestic violence?
yes,
And did she also indicate that this individual took her phone while she was attempting to call police to report this crime?
yes.
And as and how long did you spend with her? How long total did this your investigation of domestic violence? How long total did that happen?
If I had to estimate, I'd say maybe 20 minutes or so.
Okay. Your Honor, I'd like to omit the personal statements of the complaining witness under, as outlined under
I don't believe that the people have met their burden in count two. We just have some hearsay testimony from Officer Bush. As to count three, from Mr. Stevens, I know it's officer. I'm just gonna call him Mr. Stevens because I'm not sure. That he did encounter a black Charger whose license plate he could not identify. And that he did attempt to stop this vehicle, however, didn't make a stop, doesn't have any personal knowledge of Mr. McLeod, doesn't know if Mr. McLeod was or was not the driver of the vehicle. There was no testimony that he saw him driving the vehicle. And, as far as that's concerned, there are many black Dodge Chargers on the road. Was it the same black Dodge Charger? There's nothing that I heard, no testimony from Officer Stevens that would specifically identify it as being the exact same Dodge Charger because there was no plate number that was run. As to count four, interfering with electronic communications, Officer, and I'm gonna mispronounce her last name, I'm sure, but it's Milwaukee testified that there were no eyewitnesses. That was strictly hearsay. There was no corroborating evidence that a phone was taken or removed or anything of that effect. There is no complaining witness here to testify to that. We just have hearsay and nothing to back that up. So I don't believe that the burden has been met as to count four, and count five is the misdemeanor.
All right. Response to the defendant's response concerning the motion for bind over, Mr. Smith.
No response.
All right. All right, the standard for preliminary examination is probable cause being the second lowest standard, reasonable suspicion being a lower standard in criminal law. I have had the opportunity to hear Officer Wanji, Bush, and Stevens. And I believe that that the probable cause has been met concerning that this all occurred on May 13th, 2026. At 4201 Chicory Lane, and then the Chicory Lane, there was some driving afterwards, but it all appeared to be in the city of Lansing, Ingham County, state of Michigan. So location, venue, and date have been met. The defendant was identified by the witness, first identified by name by witness Wanji, and then identified by person as the person being at the scene of the crime by Aaron Bush. So identification has been made. And then we go to the elements of the crime. Count one is bound over as resisting and obstructing. All occurred on May 13th, 2026 at 4201 Chicory Lane. In that the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Aaron Bush, who testified, a police officer of the Lansing Police Department. The defendant knew or had reason to know was performing his or her duties. Count one is bound over. I did not hear any testimony concerning count two. That's Mr. Bleisner. I've heard some references that Mr. Bleisner was also there, but I don't know that that an order was disobeyed concerning Mr. Bleisner. I know an order is disobeyed concerning Mr. Bush because he indicated that on the stand. So count two is not bound over. Count three, the flee and elude is being the operator. So I find that location, offensive, venue, and date have been met on count three. The Officer Bush testified that he was a part, identifications made by Officer Bush and Officer Stevens both concerning the count three. So I believe identifications made on for a probable cause level for identification, date, venue, and location. The offense being the operator of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by, and the complaint reads Jason Murdoch. I'm going to change that because I heard from Officer Matthew Stevens. Officer Matthew Stevens said he was in what turned into a chase. it's an initial flee and elude that turns into a chase. So I'm going to say by Officer Matthew Stevens and Officer Aaron Bush, because Mr. Bush was in at the very beginning of some of the fourth degree flee and elude that's being bound over. So I'll change the complaint to read siren or by Officer Aaron Bush and Officer Matthew Stevens. A police officer who was in uniform in the officer's vehicle was identified as the official police vehicle acting in lawful performance of his duty, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey that direction by increasing the speed of the vehicle or attempting to flee and elude the officer. Officer Bush testified to the increasing speed and leaving the scene during investigation. And then Mr. Stevens testified to following. I believe that's been at a probable cause level. So counts 1 and 3 are bound over. Count 4 is the interfering with electronic communications pursuant to 768.27C. Officer Wanji or Mawagi indicated that that Ms. Lopez was the victim in the case. That she did indicate that the telephone line was willfully and maliciously prevent, obstruct, or delay any means of sending, conveyance, or delivered of an authorized communication by and through telephone or telephone line. I've heard probable cause evidence to indicate that statement, which was made under the domestic violence victim statements 768.27C, I find probable cause on location, offense, venue, ID, and date to bind over as sufficient evidence, especially on witness 1, the officer's testimony concerning that. That turns into a different issue, whether those statements can be made at an actual trial. But for preliminary examination purposes, the count is bound over on count 4, and then count 5 is a misdemeanor count that'll follow. So I'm going to indicate the examination was held on today's date, which is June 11th, 2026. And we will amend the charges. So to read that count 1 is bound over. Count 2 is not bound over. Count 3 is bound over, but in a change of, so it's Officer Bush and Officer Stevens as in replace of Officer Murdoch. And then count 4 is bound over as the interfering with electronic communications is bound over. And count 5 follows as a misdemeanor. So counts 1, 3, and 4 are bound over. Counts 2 is not bound over, and count 5 follows as a misdemeanor. So so Mr. McLeod, your time in district court is done. You're off to circuit court. Well, you'll get your next date of appearance from your attorney, Ms. Rothstein, on counts 1, 3, and 4, and then the misdemeanor count 5. Anything else for the record in docket 2601-309, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Rothstein.
No, Your Honor, thank you.
All right, Mr. McLeod, you're off to circuit court. You'll get your next date of appearance from your attorney, Ms. Rothstein. Thank you for your appearance today.
Thank you so much.
writing this, so so if you have any questions on the way. That's fine.
Yes.
All right, so here's 2601. And then, Mr. Lee, did we want to go on Leighton?
We're talking about that right now.
All right, and then, so, and we're bringing P up, that's Miss Rothstein. All right, so come get me when you're ready.
Yes.
Maybe see this.
Same,
I won't get my book. I know.
turns out.
So far, you got 2 minutes. Coming back to me. Yep. Just making sure. And I have a question. Well, because when I do, because I look it up in the garden office.
I hear that, I know what it is, because we have an office in Flores. So then I put in the state bar my regular address, because we were getting our bar notes. We were going into Black Hole, Calcutta, 40 years ago, and it was like
So are you're with the,
public defenders.
okay. all right,
2025 South Washington.
Yeah,
That's why
I wanted to double check.
Yeah.
I didn't want to put the other address on when.
Because occasionally I've gotten stuff into my home address and I'm like, but for a while, that was the only way I was getting stuff because we kind of, they were forwarding mail to we were the Napsville. And, but, you know, but it was getting, then they weren't really forwarding it. It was taking forever to get there. Then after we left the Napsville, we didn't have a place for a while because that place where we were all working from home, the 2025 wasn't ready yet. And so there was no place to send mail except to.
Right, got it.
So.
Makes sense. You might want to change it back then.
Right,
you know?
it's just with the state bar, but I didn't think that would be a thing, but I guess it's become a bit of a thing.
Well, we kind of sometimes look it up, and I just didn't know, because I was like, yeah,
Yeah, so, yeah. I don't know really what to tell you with that.
well, because I can tell you, even on our ROA, it comes up with the Okemos address.
Okay, so I'll definitely.
Yeah, you might want to
it
change.
With the state bar,
Yeah,
but yeah, that was so I could get, you know, mainly my new bar card because they had sent it to first we used to have an office over on Washington Square, then we were in the NAPS building. I'm not sure where it got sent, but they had to send it out like 3 times.
so you might want to, I don't know who else you have to let know. You might need to let the office know, because
Okay,
I don't know how that works with our system,
I don't know.
other than maybe it's pulling it from the bar. So
Alright.
maybe if you change it there, it will work.
All right, and I'll let Jackie at our office know too,
Okay.
because but I'm pretty sure that's what happened.
I'm sure you are correct.
No idea where to sit here today to stay out this way. Everywhere I sit, I see the way.
Courtroom's pretty empty now. We're asking for an adjournment on,
Well, we're gonna leave it to the court's discretion
Okay.
because I'm not sure what Mr. P's gonna say.
doesn't matter. He's been indicted. Doesn't matter.
It matters to me, but anyway, it may matter to the judge. I don't know.
He's been indicted by the feds, so on this case. So we're just waiting for
Oh,
that.
he has?
We're just waiting for that paperwork to come and then we're gonna get rid of this case here.
That's
So we're gonna ask for an adjournment.
or to anyone for that reason.
Yeah.
He's been.
Um,
So then your office is out. So they're out.
Yeah, so well, there, well, it's out of your hair now.
All righty.
Is this him?
Yes.
Oh, you can let him know.
But, no?
I mean, or I can.
Oh.
You've been indicted by the feds.
Been invited by the Fed.
Yes, on
You
this
just
case.
told me.
Yeah, on this case, they indicted.
So they're asking for an adjournment because apparently, once that happens, their office may be out of it.
Yes.
That's what I just heard from Mr. Smith just now, before you came into.
So we're waiting to receive that indictment paperwork from our office. So once we receive the federal indictment, then we'll be dismissing the case.
Like, it's cool. You've been invited by the Feds.
I mean, I guess it's a matter of fact. I mean,
Ready to go?
Yes.
Mr. Lee, our last case of the morning. Yeah, I know.
He disappears a lot.
He normally doesn't, though. I can normally find him.
ask for adjournment on that one too. So, yes, Mr. Layton,
Invited to,
maybe.
damn. Thank you on my first pistol case.
I didn't have anything to do with it. I'm just telling you what they told me. I had nothing to do with it.
What's that?
Nothing to do.
Okay. I just heard about it right before you walked in. Literally, second.
This is.
I don't know what you've been indicted for.
Me neither. I have no
Do you have
idea.
any idea? No?
No.
Okay. All right.
Our office just got a notification from the ATF. That's all we know.
Nice move.
You can still make some.
What's that?
You can still make some.
It's not.
That one that they came through last night. All we got was an downpour rain, a little bit of thunder. And that was it.
We just had a bunch of wind.
Yeah.
A bunch of wind.
So they can see my back.
I don't know. That's it. Their own business system.
Yeah.
And they have their own. They may keep. All right.
You can be seated. This is Mr. All right, so we're on the record in docket 26-01176. That is People of the State of Michigan versus Raymond P. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. P, who is present in the courtroom and seated to my right.
And sir, you are Raymond P., is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Mr. Smith, how are we proceeding? Would you like to defer to Ms. Rothstein?
Your Honor, at this time, we are asking that this matter be adjourned. It's just brought to my attention today or yesterday from our office that Mr. P has been indicted by the feds on this case. Our office is waiting to receive that indictment paperwork. So we ask that this matter be adjourned. Once we receive the paperwork from feds, we will be dismissing this matter.
All right, Ms. Rothstein, is that your understanding and how we proceeding?
Yes, Mr. Smith just informed me maybe a couple minutes prior that this had transpired, and so Mr. P is now aware of it as well, and apparently that is how we are proceeding.
All right, so I find good cause to adjourn the matter. So Mr. P won't be waiving any rights in this regard. It appears that on this file that Mr. P may have been federally indicted on the same charges, which is a good cause to adjourn this matter because then it indicates that the people may be not going forward on the state file. There may rise a jeopardy problem in this case. There may rise it, I don't know, but it is a good cause adjournment concerning to see what the feds are doing on that file. So we'll stip to adjourn for good cause this matter, and then we'll reset for prelim. And what's the time frame are we looking at?
I would have to say maybe 3 weeks.
3 weeks. I would think you'd at least.
It's gonna be July.
Okay, so July. Let's make July 9th at 9:30. All right, so we'll set it for July 9th at 9:30 for continued preliminary examination concerning this matter. And at that time, we'll have more information concerning what the feds are going to do with that issue, with that case. And I'd ask counsel to stay in touch with one another concerning this matter. So we've adjourned to July 9th. Anything else for the record in docket 26-01176, Mr. Smith?
The room with people, Your Honor.
Ms. Rothstein, do you, anything further on this matter?
No, Your Honor, thank you.
All right, we've adjourned to July 9th at 9:30. Thank you, everybody, for your appearance.
Thanks.
Thank you. Good luck.
Bring up,
Do you want the last one brought up, Judge?
Let's see, what's going on Lee, on Mr. Layton?
Well, Mr. Lee is down talking to him right now, but
All right.
we're gonna
Is that going to be a hearing or is that going to be, or we don't know yet?
we're gonna ask for an adjournment.
All right. We don't have to bring him up because we can waive his appearance. We know where he is. If Mr. Lee's talking to him, and then Mr. Lee can let him know what we're doing here. And then we have at 1:30, we have Mr. James. Is that correct?
Yes.
That's set for probation. All right.
I will be here in person.
All right. All right. So I'm going to work on a search warrant. So just let us know when you're ready on Mr. Layton, I believe.
Will do, Judge.
All right.
I need your, what's the phone number?
My office?
Yeah.
It is, I always have to look at it.
Are you here for a case?
I'm serious.
Just here observe?
517.
I figured that.
Yeah. 679. 296.
Okay.
And you've got everything.
All right.
My email address, got it all.
Cool.
And I love email. Because I can respond to those on the fly, where phone calls not always so much, right?
Right.
That can be trickier.
Needs to go in.
So Mr. Smith, we do not have anything tomorrow because I think I have a purchase, but he was contracted out because our office already represented the co-defendant. Don't know if anyone told you or not, because you're new to this.
So I typically, I mean, I did. And I mean, I didn't want to come off this roof, but maybe I did come off this roof.
You did.
But I typically ask, like, so I will ask
Looks like there's.
if your client intends to run a preliminary hearing. And I understand the fact that,
He's gonna wait to see who shows.
yeah, well, I mean.
And then you gotta tell me.
And then, I mean, if he waits to show, and
Gosh,
like,
that looks.
we're probably gonna go, like, especially if it's definitely if it's a
Oh, BO.
victim case, and we have a victim here.
But you wouldn't even tell me. You were like,
I got somebody.
that's
Yeah,
not cool.
I don't, but
I
I
got
don't
that's
get,
not
so is, is there, would there be
For
probable
what they are,
cause?
or
Who they are.
Yeah, or-
You have an ethical responsibility to tell.
try to eat.
But
some.
would
You can
there,
answer the people in your office. You don't know
Well,
that's true.
but would there be probable
You know,
cause
no
to find the case?
Oh, I see what you're saying. Okay.
The witnesses are
I thought you
here.
meant like
Can you make that determination without them being?
Baker.
But see, the problem is when they do this, they don't
Yeah,
give
they have,
you
and
the
you have to
recipe.
be here.
Oh, yeah, they do.
So
But,
police officer
no,
wasn't here.
that's
Was
not,
there,
that's not my
was
question.
there probable cause? No, there was not. They have to be here.
But even with them not here, if, based on the facts of the case.
Yeah, you just stir everything.
You
in
can make it
together.
a
Facts yet to be determined. He's innocent until proven guilty.
Well, I'm just, we're talking about a probable cause.
I understand we're talking about probable cause standard, but then,
It's
you
just a
know.
cup of cottage
if
cheese,
he
2
decides
eggs.
he doesn't do it, It's always the client's decision.
How
It's
much
not
does
mine.
it-
That's
Yeah.
number one. So,
To
you're-
wait to see if I have my witnesses here before he would.
if he's gonna
No.
wage or whatnot, right? And
Okay, well,
it's true,
that's-
that's always the client's
Well,
determination.
I'm trying to
I
eat
give
better,
him my
too, so.
advice, I tell him what could happen,
But
or worst case
I've never
scenario,
done
they
like a no
always know the
crust.
best case. scenario.
Like a
Yeah,
real-
because
I
that's something they
baked
have
a lot of
like our folks to figure it out. But it's their decision. I don't tell people what to do because I'm not the one who
Cottage
has to
cheese.
live with it, right? So, and the
Yep.
law requires that it be his or her
Of course,
decision.
I'm not saying it's
So
not.
just like you are.
My
supposed to
boy.
tell your witnesses
Oh,
that
that's
you're
Finnegan.
Ethical
Oh, he looks
obligations.
like a fin.
You
You
can
call him
disagree
Finn?
with me. You can ask Joan, you can ask
No, it's
Jen. I
Finnegan.
double check
Finnegan.
with Jen in the hallway. She was
Oh my
like,
gosh.
He's such a happy
So-
I
puppy.
have my witnesses here.
It's adorable.
You-
What kind is it?
Mini
Schnauzer?
Bernedoodle.
It's okay. And you wouldn't tell me.
My daughter Googled
He
which,
said,
because
does it matter? what
these
you
types of
respond?
dogs.
I have-
That's inappropriate.
I have the witnesses that I need
Mine
in
had
order to find.
cancer.
it.
But you
Some
wouldn't
have
say,
cancer.
you said, doesn't matter.
So
That's
she wanted to,
inappropriate. and
she
unethical.
Googled
If
one.
I
That-
say, if, in the
that
future.
No, no, no.
I
You
guess.
just need to be clear. And when I ask you a question,
Oh.
yes or no. you
That's my
answer
daughter's
yes
cat.
Or no, or tell me.
Beautiful.
That's the appropriate thing
No.
to do.
Oh,
If you have a
you
problem
should the
with
white
it,
ones
He's
are.
a,
Joel, or even Nikki
Turkish
or John, or any one of those folks that I've worked with for a long
something
time.
Turkish.
And they will school you on what the proper way it is to behave.
If I have my.
Don't ask me that question, ask your supervisor.
I'm not, I don't have to ask them nothing. I'm saying,
Oh.
I'm telling you that if I have the necessary witnesses here to put on a preliminary exam, I'll let you know I have the necessary witnesses. And we're putting on the preliminary exam.
You're not to 1:30.
I did tell
No,
you.
you didn't, you said, doesn't matter, that was your exact.
No.
response. You did not say, I asked you twice.
Finish our
morning docket,
you'll have to wait out there.
You asked me if I have.
Yeah,
the
just go ahead and wait on
necessary
No, I
Okay.
asked you, are
We
your
won't call
witnesses
you
here,
until
and you
1:30.
said,
Okay,
and I
thank you.
told
All
you,
right,
it
thank
doesn't matter. Other people heard you. from
Okay.
the office. So don't make up the story now.
Last time.
Okay.
That's what you said.
Okay,
So, which is not really forthcoming
appropriate.
So,
But.
no, he's a
but if
Turkish
We're gonna run
something.
preliminary exam, which I told you we're
Turkish
gonna run the preliminary
lingua
exam.
or something.
You were back and
That sounds
forth
about
on
right.
that.
Yeah, she's always,
I asked you.
she knew
I
the
asked you if
person,
you were running.
they were giving it away for
And
I
you
free.
said he was for you to
I'll
see,
let you show.
which
And
was
and
an
I said,
honest
okay,
answer.
and I told you, yes, we're running.
You said if everybody shows we are running. I
No,
said,
but then after that, I came back and told you we
then,
were running.
and then after that, I asked you, you asked me again, are we running?
Trying to
And
find her
I
other-
said,
she's got two
Are your
sisters
witnesses
together.
here? And you said, does it matter? And I said, it does. And you said, then we're running. That's how that comment, those are exactly how it went down. Verbatim.
Okay, but I told you we were running, right?
That's how
Your
we
behavior
actually
was
is.
inappropriate. You just acknowledged it was inappropriate.
He's a
I,
chunkster.
was
I,
also-
I,
They had to put
I
him on the
acknowledge it
line.
came off.
I've got
of
one
the-
that's a chunkster.
It was.
I'm like, that's.
Okay.
rude. He's a little
Don't worry, I'm
right,
not
let
told
me-
about it. It's
I
not-
know.
That's not your opinion. Okay, well, I'm sure he'll talk to me.
I'm
but-
sure it will.
That's her one cat.
Okay,
I'm sure.
And then the other one's identical,
Okay.
but
And in
it's
the
got,
future,
it's
you
got
might
one.
want to be straightforward and forthcoming, or not. Your
I
funeral.
said
And
well,
this
you have
one
my
has the
position. I
laugh.
told you my witnesses
Yes,
were here.
I
And they
know.
were
You
here.
did not say anything about your witnesses being here. You said, does it
If
matter?
I would run a preliminary exam, how can I run a preliminary exam without witnesses here?
I can't read your mind, Mr. Smith. You need to be honest and straightforward.
Okay,
And this one was little.
sure. All right, thank you.
So
Hydraulic first.
With a lot, like longer in the back. Okay, do we have everybody?
We are. Seeing this case picked up by the feds. By the feds, yes.
so how long do you want the case to be adjourned for?
3 weeks. I think April 9th is the,
It's better when 30 comments on
what's that?
the whole bed cases. It's not so long. Yeah.
Is there any more information about what the Fed's interest is?
I have no idea.
Thank Yes. That is one with the hot box too. These are for her for next of action. I had that Tuesday.
I had, yesterday, they had the employee appreciation. Stickers of Saddleback barbecue.
Yummy.
Regardless.
Was
of
it
what
good?
he-
It was.
He can waive.
It's hard to find really, really good. We found one in, there's one a place in Perry, Smoking Johnny V's. It's good. But for the price you pay, you get much.
I've eaten at a catered event, so never purchased anything, but there's in Holt, there's Gravity. It's a brew poison barbecue, so. We don't see the street.
Because we do, my boyfriend and I do the hot pass. For different purposes. What's it called?
Gravity?
Fed's pick it up. Yeah, they would be the Fed. It's not state.
Oh. They don't show any in Holt. Oh, yeah, they do. Summerland.
Yeah, that's a little further south on Cedar Street.
Yeah.
They're not that old. They've been there in the last 4 or 5 years.
Yeah, because his daughter got married 3 years ago in Holt at the Hidden Gem. And we were driving around and we drove by that place, but it really wasn't open. And we just went there not too long ago.
It used to be just a restaurant.
The food's not bad.
Yeah, it's used to be called Sammy's Pad.
Well, that's the one in Holt.
Gravity's got good barbecue.
All right.
Right, you can be seated. And is this Mr. Layton?
Yes, it is.
All right. All right, so we're on the record in docket 26-01213. That's People of the State of Michigan versus Zachary Layton. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Zachary DeWine Layton.
And sir, you are Zachary Layton, is that correct? All right, thank you. This time set for preliminary examination today. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Lee?
The people were asking, defer to Mr. Lee. Do you want to, if he wants to waive?
No, he still is interested in running. his case.
So.
Okay, so let's hold on because I think we just lost our recording.
Oh, now it's just.
All right, we're good. All right, Mr. Smith, how are we proceeding? And then I'll hear from Mr. Lee.
At this time, Your Honor, the people were asking for an adjournment. These, for good cause, these case is being investigated by the feds. So at this time, we would ask that this matter be adjourned for good cause.
Okay, we adjourned for good cause on May 22nd. Mr. Lee, how are we proceeding?
Well, Your Honor, we're here and we're ready to run the exam. This is the first that we have heard of the feds being interested in this case. We don't know what their interest is or why they would be interested in this case. But we're here, we're ready to run, and so we would ask the case either to be dismissed. Well, yeah, we just ask for the case to be dismissed. They can reissue it if them and the feds decide it's worth.
Okay, we had a PCC on May 15th. And I denied modifications at that time. Those requests for bond modifications. On May 22nd, there was a good cause adjournment, and we set it for PCC on June 4th and preliminary examination on June 11th. On June 4th, we're leaving on for preliminary examination on June 11th, and then we're here on June 11th for preliminary examination. And the people requested an adjournment in the matter. Because the feds are looking into this. When did we get any notice that the feds were involved, Mr. Smith?
Your Honor, I just got off notice from my office yesterday. I can assure the court that if this matter is not handled by the next scheduled preliminary exam, if the court would allow, then we will dismiss.
Are there any officers subpoenaed for the file? We can start the prelim today, and then are there any officers who are here on this case?
There's no officers here on the case.
All right, well, we've already had one good cause adjournment on May 22nd, so I'm going to dismiss without prejudice. So Mr. Layton, this could be reissued, okay, by the prosecutor's office. It's going to take back, they're going to review it. And they could reissue, which starts the whole process over again, okay? But for our purposes today, the case would be dismissed. I think this is on an information. So we'll dismiss without prejudice. And then you may get a federal warrant out for you. You may get a state warrant out for you if they reissue on this, but it's dismissed without prejudice. Then we'll do a nollie pros to that effect. The court will sign a nollie pros based on the defendant's motion to dismiss. So this could be reissued. Usually we default with the dismissal without prejudice. In this case, it could be reissued if it's not followed up on, but that'll start the whole process over again. You'll be rearranged, things of that nature. Mr. Smith will let Mr. Lee know if this is going to be if there's going to be another if it's going to be reissued, and then we'll go from there. All right, so based on the defendant's motion, it's dismissed without prejudice. Anything else for the record in docket? I'm indicate that people are unable to proceed. No witnesses. See, no witnesses. And I'm going to deny the request for adjournment. All right, so that's all in 2601-213. I do not have a no contact order GPS, but you may want to carry a copy of the dismissal with you. It takes about 4 hours to purge from the system.
Yes.
Anything else for the record in 2601-213, Mr. Smith?
Nothing from the.
Mr. Lee?
No, thank you.
All right, we're all set. Thank you for your appearance today.
Thank you.
And you can get a copy from the order from my court officer, okay? All right, and then I will see, so who's covering the probation violations? That's Mr. Harris or Mr. Smith, is that correct?
Yes.
All right, so I'll see everybody at 1:30.
Me too. He doesn't want one.
All right.
Yes, please.
Maybe see him.
No.
We're done. Filed the next day.
Okay.
Morning Bay.
Right. Going somewhere for lunch?
No. I thought
Oh,
about
I
it.
was gonna look and see what's going on. at the Cap today.
I did hear of a new pizza place called Shut It.
Here?
Yeah, Carisha went there. I'm gonna Google it.
Today is Check Your Heart Capital Rally.
My ticker's just fine.
It's a felony. Yeah, but it was supposed to be, so, it's a felony, it was felony prelim. It.
Oh, it's a pizza
supposed to
truck.
be indicted
It
by the
doesn't open
feds.
till 2.
It hasn't been indicted by the
Where does
feds
it
yet.
sit?
Sarah asked me to see if we could get it adjourned. While they did that, the judge said no.
Carisha
And
said
dismissed.
right around the corner.
I know. I know
Because we
that,
had it, because we had it
I know, and I wonder if that was the
adjourned
truck.
for good
But
cause back
she-
in May.
it looked
So
like
I just
her
wanted to give you a heads up and give Sarah a heads up.
It was during the Boy Scout rally the other day.
Yeah.
So I wonder if maybe it comes during some of the rep. I don't have
Yes, whereas
a view
Zachary
of the
Spinach.
courthouse like you guys do.
Spinach, garlic, feta, chicken. Chicken artichoke pesto.
yes.
02666. That is People of the State of Michigan versus Minnie James. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Tyler Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Ms. Minnie James, who is standing to my right.
And ma'am, you are Minnie James, is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a probation violation hearing. The arraignment was on May 21st, 2026, and then we've set it for June 11th today. Mr. Smith, how are we proceeding?
It's my understanding that the Ms. James wants a contested hearing, so we are prepared to move forward with that hearing, Your Honor.
And is it, so we would need I see Ms. Bayless here. Is it Mr. Neves or are you acting as the probation agent?
I'm filling in for Joe Sumter.
Okay, for
today,
Joe
but
Sumter.
I'm well versed on the violation.
All right. Is that a fair statement, Mr. Smith?
Yes, Your Honor.
Yes, it is.
All right, all right. So we'll have the hearing. We'll call Ms. Bayless up. The allegation, you have the allegations, is that correct?
Yes, Your Honor. I've reviewed the allegations and recommendation with Ms. James.
All right. So we'll have Ms. Bayless come up as the acting probation agent for Joseph Sumter. And Ms. Bayless, I'm going to have you state your first name and last name and spell them both for the record.
Jody Bayless, Baylis.
Please raise your right hand. Do you solemnly swear from tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
All right. Yep. Go ahead and have a seat. The voice goes to the court recorder's ears, so please project as best you can and when we're ready.
Thank you.
Thank you, Your Honor. Officer Bayless, I'm gonna ask a couple questions we previously discussed about this file occurring on April 1st of 2026, right? Officer Bayless, are you currently employed?
I am
And where are you currently employed?
here at 54A District Court.
And what is your position at the district court?
Chief Probation Officer and Sobriety Court Probation Officer.
How long have you been in that capacity?
As chief, a few months, but over 3 years as a probation officer here.
Okay. And are you familiar with Officer Sumter's file in this case?
I am.
Have you had an opportunity to review that file as it relates to a violation for Ms. James?
I have.
Can you tell us first, are you familiar with Ms. James?
Not personally, I've reviewed her file for this matter.
Have you been able to identify Ms. James in any way?
I can, based off her AberHealth picture associated with her account, the PO setup.
Can you identify her as president of the court by an article of clothing?
I can, her gray shirt.
We'll stipulate to identity.
All right, thank you.
So are you familiar with when Ms. James went on probation?
She was placed on probation. She was sentenced in December and followed shortly after with her probation officer.
Are you familiar with the terms of that probation?
I am.
Was one of those terms that she is not to drink alcohol?
That is correct.
Again, I'm gonna direct your attention to April 1st of 2026. On that date, did your office receive a violation?
We did.
Can you tell us what that violation was?
We received notification, well, the probation officer assigned to the case received notification that the client had a positive test for alcohol from AberHealth.
And this is a ETG. Can you describe for the court what that is and what that means?
So listed on the violation is a ETG result. This is the alcohol that is still present in the person's body prior to being processed through the liver.
Okay, so there's alcohol when it's processed through the liver and then when it's not processed.
Correct.
So what does a positive ETG mean?
So positive ETG means there's been an alcohol event or consumption and the body is still waiting to process that through their liver.
And are there false positives or are there any, do you know of any like medication or any type of substance that would elicit a false positive? Like, let's just say if I drank some mouthwash before I went into to test, would that potentially give me a false positive for ETG?
Potentially on the instant cut, but not the lab confirmation.
Okay, and particularly as it relates to this defendant, are there, with regards to probation process, does she need to report any medication that would elicit a drug or an alcohol event?
They are required to produce and give their medication list to the probation officer to upload into the testing site.
Does this defendant have any medications listed on her site?
The probation officer listed no medications in its notes, nor was there any medications listed in the AgriHealth testing site by the PO or the testing company.
Is it her duty to report that medication if she has it or she is going to consume any medication that may provide a false positive?
Yes, she needs to produce any medication to the probation officer.
And as you currently have read the report, what is your recommendation based off of the alleged violation here?
On the violation, it lists an ETG, but the defendant also has an ETS. So that goes with the test. So based on her high levels past a cutoff for ETG and almost high levels for the ETS, it would show an alcohol consumption event had occurred. And this is the client's second alcohol consumption. One pled guilty to, this is one alleged additionally.
All right, no further questions.
All right, cross-examination, Mr. Smith.
Yes, Your Honor, briefly. So Ms. Bayless, you do not know Ms. James, is that right?
Not personally, no.
Is this your first time meeting her, being in the same room?
Correct.
You mentioned the allegation is drinking alcohol, is that right?
The violation is for having a positive test.
Yes. You mentioned earlier that drinking alcohol was the violation. That's certainly one source of alcohol, right?
Sorry, say that again.
Drinking alcohol would be one source of alcohol that would appear on an ETG.
Depending on the level, how it would appear, correct?
Well, certainly, but given a say a heroic level of alcohol consumed by any route, drinking it would be one way for it to wind up on an ETG. Is that fair to say?
Yes.
Is that the most common way that this happens?
To get a positive ETG result?
By drinking alcohol?
Correct.
Is that the only way it can happen?
I'm sure there are other ways alcohol can get in your system.
Have you encountered any?
No.
Okay. You mentioned the ETG and the ETS tests. What is the distinction between those two tests?
In terms of can you?
What do they measure?
So you have their ETG, which measures the alcohol still in your body that has not been processed by your liver. Then you have your ETS, which is alcohol. It's almost like a metabolite that has now been processed through your liver.
Okay. And how are those different measurements useful in your employment? That is, what do they mean to you?
It can tell us, one, if the defendant maybe potentially came into the testing facility still having alcohol and recent drinking. It can tell us past drinking up to a certain point.
Okay, so one of them is reliable over a longer period?
I don't know the exact science in terms of length of time. I guess what you're asking.
Is it possible to be positive on one and not on the other?
Yes.
Under what circumstances?
Well, positive on which one are you asking and not the other?
Well, it's either way around. I'm just asking as far as your knowledge.
There is potential to be, you can be positive ETG, no ETS. You can also be positive ETS, no ETG.
Okay. You mentioned, as far as your examination of the results, that the ETS was almost high level?
Almost past the cutoff.
Almost past the cutoff. Okay. Are you aware of any medical treatment that Ms. James received?
None that was noted by the current probation officer.
Okay. Have you encountered in the past situations where a probationer has been hospitalized?
That I've had, are you saying that affects their alcohol or just had a participant?
At all?
I've had clients hospitalized for reasons.
Okay. While they're in the hospital, are they expected to, conscientiously update whatever meds they're receiving while they're in the hospital?
We do ask for them to fax it, or upon discharge to fax it to the PO or bring it in upon discharge.
Would you be aware that Ms. James was in fact hospitalized shortly before this test?
None that was noted by the probation officer.
Okay. So as a hypothetical, if she were to be hospitalized and given medications of some sort and just failed to turn in that documentation, that would be a violation, right? Just failure to turn in the documentation.
It would be at the probation officer's discretion.
Okay, it could be a violation.
It could.
That's fair to say. But the simple fact of being prescribed a medication that might have resulted or shown up positive on a drug or alcohol test, if that is in fact a prescription, that would not be a violation. Is that right?
In my experience, I've never seen it. Well, no, if they're prescribed something that's approved by the probation officer, but I've never seen a medication that can give you those results.
Okay. Is one of the common terms of probation the requirement to take medications as prescribed?
Yes.
I don't have any further questions. Thank you.
Any redirect, Mr. Smith?
Yes, just again briefly. In how long you said you've been a probation officer?
Here over 3.5 years.
Were you at another?
Yes.
How long you been probation officer there?
2 years.
2 years, so five years total?
Yes.
Have you ever seen a person take a prescribed medication and then that medication caused them to fail a ETG?
Not like this, no.
Oh, that's no, nothing further.
All right. May this witness be excused from the people?
Yes, Your Honor.
Mr. Smith, may this witness be excused?
Can I ask one on refresh?
Sure.
The last question you mentioned, not like this. Under what circumstances have you encountered something along those lines?
It was someone taking a medication with alcohol that caused a higher, it was codeine and alcohol.
Thank you. I have nothing further, Judge.
All right. May this witness be excused, Mr. Smith?
Yes, Your Honor.
All right. You're excused. Thank you for your
Judge.
appearance today. Any further proofs or any further witnesses today, Mr. Smith?
No, Your Honor.
Mr. Smith, do you have any evidence to put on the record?
No exhibits, but I would call Ms. James.
All right. So Ms. James, you can come up here. And you can come right up to the stand here, and I want you to state and spell your first name and last name for the record.
Okay.
So what's your name, ma'am?
Minnie James,
And Minnie spelled?
Minnie,
And James is spelled?
James.
Okay, please raise your right hand, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? You're gonna have to raise your right hand.
Okay, sorry, my hand is a little shaky.
Okay. So do you promise to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. You can have a seat in the witness chair.
Okay,
Please project as best you can.
okay.
And Mr. Smith, when you're ready.
Yes, Your Honor. So Ms. James, just a few straightforward questions.
Okay.
Did you hear when I mentioned earlier, asking Ms. Bayless about whether she knew that you'd been hospitalized?
Mhm.
You were.
Is that a yes, ma'am?
Yes.
You gotta say
yes.
verbally, say yes.
Okay, yes,
And you were hospitalized. Is that
yes.
correct? Around when?
I think probably like 2 weeks before
Okay.
I did my second run.
Okay. And for what reason?
Just flu, coughing,
Yeah.
and like fever.
So you went to the hospital. What happened when you went to the hospital?
I was just checked out by the doctor and then confirmed that I was sick. that I was coughing. And so she gave me some medications, like an IV
Okay.
type thing.
Do you remember what the medications were?
One was, I think, two, like a cough syrup.
Okay.
And then one was codeine for just not feeling well.
Okay, so like, was that like a liquid or what was it?
One was a pill and then one was a liquid.
Okay. Do you remember any like brand names or specifically what the medications were?
No, she just told me to take it until it's all gone.
Okay, and this was approximately 2 or 3 months ago.
Mhm.
Okay,
So
Said
I-
yes, ma'am.
Oh, yes, yes.
okay. So for what period of time did you take those medications?
Probably like for a whole, over a week, probably.
Okay. Was that in accordance with the instructions the doctor had given you?
Yeah, she said take it all until it's done.
Do you have documentation of that here today?
I do have the bottles with me still at home, but not with me.
Okay, but you could produce those to your probation officer
Yeah,
if needed. Okay,
yes,
along with any necessary documentation.
yeah.
You understand?
I just couldn't find it.
Okay, you understand you're supposed to turn those things into your PO, is that
No,
right?
I didn't know that. I did let him know that I was sick and that I was taking medications. But he kind of just act like he really didn't, he wasn't like talking about that. He didn't. But I did tell him
Okay.
that I was sick and that I was taking codeine and off start.
Okay. But given enough time, you'd be able to produce those records and those medications.
But that was after the second.
After this test.
Yeah, so then I explained to him that
Okay.
that's the medicine I was taking.
Okay.
But I did let him know I was sick before I took that shot.
Okay. And during this time, you weren't drinking.
No, I'm following everything he told me to do.
All right, and you haven't been drinking since that time either.
No.
Okay.
Not at all.
I have no further questions.
All right, Mr. Smith, cross-examination.
Ms. James,
Yes.
how long have you been on probation?
Almost like. I'm almost supposed to be done. I think probably. I don't know.
You
I'm
don't
not
know?
sure, no.
You know,
But I know that it's I'm supposed to be done, I think this month.
Supposed to be done tomorrow.
Tomorrow,
Yeah.
yeah, so, yes,
so originally, how long did you get put on probation?
I think 6 weeks. Or,
6 weeks?
I'm not sure, but it's been enough time for me to, I did 2 classes for anger management. So
No.
that was like for 2
Ms.
weeks.
James, I just wanted to know how long you were on probation, right? So, you know, as a part of your probation, you're supposed to update your probation officer with any prescription medication that you take, right?
Now I'm just now noticing that, but I did.
Did he tell you that
No,
originally? He never told you that you were supposed to update
No.
that.
no,
He did not tell you,
no,
never told you, okay?
no, sir.
And you know that you're not supposed to consume alcohol, right?
Yes,
He did tell you that though,
yeah,
right?
yes,
No alcohol, okay. And you said that you were in the hospital a week before the April 1st.
yes,
What hospital?
Sparrow.
Sparrow Hospital?
Mhm.
And they gave you some medication, right?
Yes,
What was that medication again?
I don't know really, just the IV and one was codeine and one was a liquid after.
And they gave you that after you left the hospital?
Like a prescription.
When did you get the prescription filled?
I think like 2 days after, because I didn't have my ID to pick it up, so I had to get a ride and have somebody else go help me get it.
You know you were coming into court today, right?
Yes,
And you could have brought that stuff with you.
well, I wasn't.
The question was, you knew you were coming into court today, right?
Yes,
You could have brought your prescription with you today, right?
yes,
And you did.
I couldn't find it.
My question is, you did not.
No, sir.
Okay. You could have, if you couldn't find it, or you lost it, or the dog ate it, you could have went back to the hospital and picked up that information and brought it with you today, right?
Yes.
I'm sorry?
Yes, I didn't think of that though.
Okay,
So sorry.
that was not my question. My question was, if your dog ate it, or you lost it, or you couldn't find it, you could have went back to the hospital, got a copy of it, and brought it in us today, right?
Yes,
And you didn't do that.
I didn't think about it.
It's-
I didn't know.
It's a simple yes or no.
Yes,
You know you didn't do that, right?
yes,
And you said it was codeine?
yes.
Did you drink it all at once before you went to this?
No, that was a pill and then the other,
My question is, did you drink the entire bottle of codeine before you went to test on April 1st of 2026?
yes, that's what I was told to.
Did you
She said take it until it's done.
my question is, did you consume the entire bottle of codeine all at once
No,
before you went to test on April 1st?
no,
That's my question,
no.
right?
I didn't do
No.
that.
You took it as prescribed,
Yes.
right? How much did it say?
I really don't know. I didn't really look at it. I was sick, so I was just taking it 2 times a day. That's what I was told to do.
How much?
Just a capful.
So you don't know the amount, just
No.
the cap. And you don't deny that you tested positive for ETG. You don't deny that, right?
No,
So you,
but I was just confused because I didn't. It was like I didn't know that.
my question is much simpler than that.
Okay.
My question is, you don't deny that you tested positive as prohibited by your probation for ETG violation.
No.
Do you deny that?
No.
No further question.
Any redirect, Mr. Smith?
This was months ago, right?
Yes.
Do you remember many fine details about things that happened 60 to 70 days ago?
You guys said I'm supposed to be getting off soon, and I graduated the class that I was supposed to do.
Yeah, just do you remember what shoes you were wearing exactly 62 days ago?
Probably some sandals.
Yeah, you can guess, but you don't necessarily remember things exactly that far back. Is that fair to say?
No.
You think most people would remember things with that level of detail that far back?
No.
And no further questions.
Right. May this witness be excused from the defense?
Yes, sir.
Thank you.
Can this witness be excused from the people?
Yes, sir.
You're all set, ma'am. Thank you for your
Thank you.
appearance. Any further proofs today, Mr. Smith?
No.
All right. Recommendation or argument, Mr. Smith, and that I have two Mr. Smiths. That's why I keep saying Mr. Smith.
Yes, Your Honor, we're here today because the defendant got a positive ETG. I mean, I think that's the only issue before you today. The defendant does not deny that she tested positive for an ETG. You had testimony here from the probation officer who said that the defendant tested positive, got a positive ETG. And I mean, I guess that's the conclusion, right? There was a positive test. Now, whether that test was because the defendant took codeine, I don't know. Maybe she did take codeine. She didn't provide evidence of that today. And she was supposed to, as you heard testimony from the probation officer, she was supposed to provide the office with that medication if she needed to take that medication in order to put them on notice that she may test positive. She didn't do that. She didn't do that before she went into a test on April 1st. She didn't do that since April 1st, and she didn't even bring that proof in here today. So with that said, it's hard to believe that coding would cause this type of test. And you heard from the probation officer that in her 5 years of service as a probation officer, she's never heard of it. So, Your Honor, based off those facts, I ask you that you find the defendant, she did in fact violate her probation.
All right, thank you. Response, Mr. Smith.
Yes, Your Honor. I find some elements to agree with in the argument of people. I think it's fair to say that had Ms. James turned in documentation of her prescription medications, we likely would not be here today. The court will recall Ms. Bayless's testimony that the single set of circumstances in which she could conceive of these facts occurring, or facts similar to these, is in a situation where the individual has consumed codeine as well as some amount of alcohol, whether small or large. We don't know what these prescription medications were, but we do know that one of them, according to Ms. James' testimony at least, was codeine, and that another was a liquid. I'll submit that it is relatively common for cough medications to contain some small amount of alcohol as part of the mixture. If the violation today were failure to document prescriptions, I don't think we would have contested it. But I would submit to you, this is the rare circumstance where a failure of documentation resulted in a violation here today that may be explained by my client complying with her terms of probation, taking prescription medications as prescribed. We've heard testimony about that in from several angles, I think it's fair to say. Inasmuch as the court may be prepared to find that some violation did occur, I would ask that the court consider termination at this point, irrespective of what did or didn't happen with regard to this violation. It seems that Ms. James has completed her anger management courses and essentially every other responsibility of probation, with the exception of this one, should the court so find. If the court is not willing to terminate successfully at this point, I would ask the court to adopt the recommendation of the probation office, simply so that Ms. James can prove that she's not been consuming alcohol with the benefit of a scrum tether. That should allow some time to build up that period of documented sobriety. The court will have taken note, in fact, the court recited that the original end date of probation was to be tomorrow. It's regrettable that we're in these circumstances, especially, as I stated a moment ago, this could be attributable to a simple failure to document. So regardless of the court's finding with regard to whether a violation did occur, I would ask that the court terminate probation successfully, and failing that, adopt the recommendation of the probation office, simply so Ms. James can prove that she's not been consuming alcohol.
Right, thank you. Any response from the people, Mr. Smith?
Yes, Your Honor, I don't think it's in dispute whether the violation occurred. You got it right here. It says it over there. She tested positive on April 1st. So I think we were only here for the probation officer to give you concrete testimony that happened. And from my understanding, that the defendant has not been testing for as required since April 1st. So she hasn't complied with your court order since April 1st. So again, Your Honor, I would just ask that the court keep that in mind and enter its ruling, and I'd ask you to find her guilty.
You may.
As the people referred to allegations that haven't been addressed, I'd like to briefly respond.
You may.
Inasmuch as no testing has happened since that time, I have reason to believe that that's due to the fact my client can't afford the nominal fee that comes with the testing requirement. If Mr. Sumter were here today, I would have inquired about that, but I know Ms. Bayless is not hasn't necessarily been there for those conversations as Sumter has done, or Mr. Sumter has done. So I just ask that the court not consider any allegations not strictly relevant.
All right, thank you. After hearing the testimony of Jody Bayless concerning this probation violation hearing, the allegation is the consumption or testing positive for urinalysis for alcohol. There's no doubt she tested positive. So why? Why did she test positive? And we have to look at any type of evidence and credibility of evidence concerning why she tested positive for alcohol. And Ms. James has not come up with any documentation or evidence indicating that anything that she previously indicated was true. We have nothing to state from a hospital. We don't have any prescription medication. We don't have anything but her word indicating that. And then we have a previous, she's tested twice, and she's tested twice, and both times are positive. So I don't know what to do with Miss James concerning alcohol. You're working right now, from just the reading of this, you're working on an alcohol problem. Okay. At least the first time was completely, you waived your hearing and you indicated that, I've got it right here. You indicated that you're pleading guilty. You waived any probation violation hearing and admit to the above allegations of testing positive per AberHealth on February 24th. You signed that April 1st. I find that the people have met their burden by preponderance of the evidence, which is required, and therefore I find you in violation of your probation, mostly because, and Mr. Smith is right, you don't have any documentation concerning what prescriptions, when you were in the hospital, what you were in the hospital for. We have nothing to that account. All we have is your sworn testimony, and that's not going to carry the day today. All right. So I'm going to extend probation, and we're going to extend probation because district court's not helpful at times, but we try to be helpful and we try to get to the source of the problem. And the source of the problem appears to be drinking here. Okay. And this stems from an MDOP A and B file that was pled to MDOP. So, so I don't know if this is an ongoing problem or not, but I do know that you've tested twice positive for alcohol. All right. So we're going to extend probation to let's make it August 17th, 2026. We're going to place you on a scram tether for 60 days. So scram tether is placed for 60 days, just to see if the remainder of probation you're going to test positive for alcohol. That, and the scram tether will indicate to that right away. Okay, we'll get some indication. And so I'm going to extend probation to August 12th, 2026. We're going to place you on 60 days of scram tether. Probation is just another way of sentencing. Okay. And we've had people who want to work with you to find the source of the problem. I'm not concerned about Minnie James now. Okay. Minnie James is going to have to test positive or not test positive, and then you'll be sentenced to jail because you're under the guise of you're not supposed to get alcohol in jail. Okay. It becomes a problem. I don't know that happens or doesn't happen. I don't know what happens in jail. What I do know is when you're out and you're testing, you're coming back positive, and that's a problem. Okay, that's a problem, and we're trying to fix that problem. Okay, the other answer to the problem is we can just sentence you to jail. Okay, but that doesn't solve the problem. Okay, that doesn't solve the underlying problem. And I'm trying to fix the problem. If there's a problem, I'm trying to see what we can do. At least give you some tools to see what we can do to fix the problem. If that's not an issue, then this shouldn't matter. None of what we're doing should matter. Okay. Then the scram tether should come back as negative, and for the next 60 days, it's your time to shine. Okay. If this does come back, then we know there's a problem. Okay. And you've got to help us fix the problem. You've got to invest in yourself to fix the problem, because if you don't, then Minnie James is going to come back to this court, and we're trying to fix the problem that led to coming back to court. Okay, that's what we're trying to fix that problem. If this happens again, you need to keep the prescription, the documents, anything as part of a documentation. So it's not just you coming and testifying. I believe Mr. Smith's right. If you weren't showing the documentation, maybe we wouldn't have a hearing today. But you came, we had the arraignment as of May 21st. We came of June 11th, and you came with no evidence or documentation. And that becomes problematic, you know. So I'm going to extend probation to August 12th, 2026. We're going to place you on a scram tether for 60 days. Keep in contact with Mr. Sumter, your probation agent. We're not going to address jail or anything like that at this time. This is what we consider a second violation, okay? And under what you pled to, the sentencing, I believe I held 91 days back, but this is a second violation, and we're right at the end of the violations. We're not going to worry about that right now. What we're going to worry about is making sure that if you are clean, you're staying clean. Okay. All right. Anything towards a judgment, a sentence. I've extended probation. I've indicated a 60-day scram tether, and to report to Joe Sumter, her probation agent, concerning this matter. Anything else for the record in 2502666, Mr. Smith, from the people?
Nothing from the people, Your Honor.
Mr. Tyler Smith, any questions concerning the ruling of the court? I'm just extending probation and keeping your client on 60-day scram tether.
Of course, quite clear. I have no questions.
All right.
Are you waiving oversight fees for the extended probation?
Yes, oversight fees for the extended, that's a great question. Oversight fees, since we'll be on probation for 2 more months, you'll be responsible for $30 a month per probation oversight fees. So that'd be $60 for the extension of probation. Keep in contact with Mr. Sumter, because Mr. Sumter's who you want to keep happy concerning this documentation, anything concerning your testing, your problem with testing. He only knows from what he sees, what he reports from you. If you don't tell him that you've been in the hospital or that you've taken some type of codeine, or if he knows a reason why you're testing positive, that might change things. He had none of that. And so he violates you. And once again, you've tested positive once before. So this becomes problematic. Good luck to you, Ms. James. All right. Mr. Smith, Tyler Smith, thank you. Mr. Smith, thank you for your appearance today.
Thank you.
And for your work.